Arbitration, must have heard, Madhyastha, is a very commonly used word and adjudicatory process, but it has many challenges. In the Code of Civil Procedure, before 1908 CPC, there was a provision of arbitration in the old code. But subsequently it was removed. The Arbitration Act came into picture in 1940. And that 1940 Act was repealed in 1996. The 96 Act takes into consideration mediation, conciliation, and arbitration. Arbitration is adjudicatory process where somebody acting as an arbitrator decides the dispute, whereas mediation and conciliation are voluntary settlement with the intervention of a third person. But it is a voluntary settlement, whereas the arbitration is adjudicatory. Our 1996 Act has been amended thrice in 2015, 2019 and 2021, but it has still many challenges. What you will hear about the arbitration is, it is ad hoc arbitration generally, where the court appoints an arbitrator under section 11(6) of the Arbitration and Conciliation Act, where earlier it was titled as Chief Justice of the High Court or Chief Justice of India in the case of international disputes. Now it was changed to the High Court or the Supreme Court. But the fact remains that arbitrators are appointed by the court. If there is no agreement, the arbitrators are appointed by the court. There is unknown clause in section 11(5) and 11(6), where the Chief Justice earlier, now the High Court or the Supreme Court, can designate an institution also to appoint arbitrators. I must have read section 11(6) couple of times, but this part, that the institution could also be designated, was not known to me, to be honest. I was lucky. Two Honorable Chief Justices of my parent High Court have delegated me the power of the Chief Justice to appoint arbitrator. I exercised that power for a year each, for almost 2 years. But this fact, nobody argued it, nobody knew it, and actually there was no institution in Punjab and Haryana, I would say so. But I was in 2 other courts, there was also no institution. Delhi has one institution, Delhi International Arbitration Centre. Mumbai has one. Hyderabad has one. There are many others. But the court generally appoints the retired judges as the arbitrator. There are certain advantages of the retired judges, but certain disadvantages also. In ad hoc arbitration, there is no cap that how many hearings will take place, how much time. Recently in 2019 they fixed time, but still generally it crosses that time limit. But fee is again made part of Schedule 4, that is 30 lakhs, that is upper cap. But recently Supreme Court in a judgment, ONGC versus AFCON, said 30 lakhs is fee which is applicable to claim and counterclaim. So it comes out to be, in a given case, it can come out to be 60 lakhs. But this fee, 4th schedule, is not applicable to the institutional arbitration. Delhi High Court in Delhi International Arbitration Centre is managed by the sitting judges of the Delhi High Court. They have framed new regulations for conduct of arbitration, which are applicable from today. 1st of April is the date of commencement. They have fixed the fee, cap of the fee is 60 lakhs. But fee is only one part. The fact is, I'm not very sure that in how many cases Delhi High Court has nominated or designated an institution as an arbitrator. I was appointed as an arbitrator by Delhi High Court, not as institutional appointed. Delhi High Court appointed me. There are many other instances where High Court is appointing individuals as arbitrators and not the institutions. In respect of institution, the fee is known beforehand, that this will be fee payable, and also the timeline is fixed under the act also, but still you will like to maintain the timeline. But basic advantage between ad hoc arbitration and institutional arbitration is that where in ad hoc arbitration there is no limit that how many sittings you will conduct, whereas in institutional arbitration, whatever sittings you conduct, there is a cap of the maximum fee which will be paid, and everything is known beforehand. Nobody can have a grievance that I was charged extra. There is a constant problem about high charging of a fee. Like in ONGC case, also the public sector was aggrieved against the charging of fee by the arbitrator. Somewhat similar matter came up before me in the High Court against raising a grievance of charging of a fee by the tribunal, 3-member tribunal. If I remember correctly, their grievance was that 80 lakhs has been paid as a fee, but still the stage of issues have not come. They wanted to seek the termination of the mandate of the arbitrators so that it can be decided by civil court. As in Delhi, there is the original jurisdiction. In Punjab, there is no original jurisdiction with the High Court. So question is that such application would be ordinarily maintainable before the original jurisdiction, that is a district judge. I said that you have to go before the district judge. But their grievance was that the tribunal consists of 2 retired Supreme Court judges and another retired judge of the High Court. We can't go to the district judge. It will be very embarrassing for us and for the arbitrator to go before the arbitrator. So after hearing learned counsel for the parties, I decided, we are governed by the latest patent, that is Royal Charter of the King, where there is a clause that the High Court can withdraw any case or permit the parties to file original suit before the High Court. So I allowed them to entertain that application in the original jurisdiction of the High Court. So naturally, one party was not happy about it. They came before the Supreme Court. In the Supreme Court, they didn't go into the merits of the controversy. They agreed for appointment of a sole arbitrator. That finished, the arbitrator has given the award and other things. These are the issues which come up before the ad hoc arbitration. No cap of fee, no cap of hearings, so which lead to multiple issues. So therefore, generally people say if you read, go to the websites, you will find ad hoc arbitration is cheaper, it is faster, but the practical experience is otherwise. One of the lawyers told me that one of the ad hoc arbitrator was paid a fee of 70 lakhs and still there was a demand of 15 lakhs as a reading fee. The parties have no option. If they don't pay the fee, even their 70 lakhs go down the drain, because the new arbitrator, even if appointed, will demand the same fee again. So they had to pay. Should have paid. I do not know. I will not say anything about that. But the question is, ad hoc arbitration has pitfalls. On the other side, institutional arbitration is promising. I'm told there are about 35 institutions in India dealing with arbitration. 3 of them I have named: Delhi, Bombay, Hyderabad. There is a Gujarat is starting another one. Goa is starting another one. There are many others. There is a FICCI mandated arbitration, Indian Council of Arbitration. They are also in field. The idea is that institutional arbitration should be able to provide the dispute resolution in a known method, and which can be speedier. Of course, it will depend upon the quality of the arbitrators which we associate with. And for association of arbitrators, we have framed the regulations. We have a very esteemed panel of known national and international arbitrators. Justice Sikri is one, Justice Indu Malhotra is one, Mr. Salimullah, who is a King's Counsel in London, is one Sherina Petit is one. There are many others they are total of 10. So with that level of the members who will impanel arbitrators, we can be sure of quality impanelment of the arbitrators. Another thing is that in one of the seminars, Chief Justice of India said that this old boys club syndrome should not be there. One can know what is meant by the old boys club. I will not elaborate on that, but to meet that objection, or maybe the mindset, we have made eligible the candidates from the age of 35 to 75 as the arbitrators. Why can't a young lawyer with some experience of, generally you will join a profession at the age of 24, 23. So if you have gained an experience of 10, 11 years as a lawyer professional, why can't we trust you as an arbitrator? Why can't a chartered accountant be trusted as an arbitrator? Why can't an engineer be trusted as an arbitrator? So if we rely upon such young blood, probably the face of arbitration in India will change. Just for your information, in worldwide, the retired judges are not the sole arbitrators. They are all from different professions working as arbitrators. So same, I think, mindset we need to develop in India, where the persons from varied fields can work as arbitrator. Their experience, their without any baggage, it will be better for the arbitration. There are other issues which faces Indian arbitration system is post-award. Post-award is section 34, objections are filed, which are not decided for long time. I just want to share one case. There was an Australian company by the name of White Industries. they entered into an agreement with Coal India. So the award went against Coal India, but the objections were filed. Objections were filed before two forums, Delhi and some other. Objections were not decided. India is signatory to Bilateral Investment Treaty, BIT. The white industries invoked the jurisdiction of BIT to say that Indian judicial system is not effective. Therefore, we have failed to get a redressal of our grievances for Indian system. You know, the award went against India, and Indian government has to pay white industries the amount of the award, which possibly could have been paid by Coal India, if or whatever, you know, good, bad, indifferent, the decision had to be there. There was no decision. So these are the issues which arise. Our legal system is known for delays, but the arbitration can change. The arbitration, you know, there are multiple forums of appeals against the award of the tribunal also. Firstly, before district judge, like in Delhi High Court, it will go before the single bench, then intra-court appeal, then Supreme Court, 3 forums. Same thing before the other high courts where there is no original jurisdiction, like in Punjab. The objections will be filed before district judge, appeal will come to the High Court, and then second appeal or special petition will come to the Supreme Court. So multiple forums delays the finality of decision. The grounds of challenge is if the award is against the fundamental public policy of India. It's quite vague, indefinite, and then it was interpreted as if the award suffers from patent illegality, it will be ground for challenge. What is patent illegality is again not very clear. So under the ground of patent illegality was taken away in respect of objections against the award of the international arbitration, but against the domestic awards, they are still available. So there are multiple issues. Whatever you may say, you know, in one of the conferences, one of the panelists said that in England 20 awards were given, 5 objections were accepted. So I said that even if 5 objections, even if in one case the objections are accepted, means that arbitrators are not infallible. They can commit a mistake. So therefore, we can't permit the arbitrators to be arbitrary also. So there has to be a ground of challenge. Only thing is that the satisfaction of the court should be recorded at the earliest so that there is a quick decision, finality to the dispute.